So for him to take her order and go, what about you? What do you like? And you're just like, he knows what she likes. It is a wild thing to say, and it was not in the script, and it was crazy. When I found that in the edit, I was like, oh my God, why is this not in the movie? And then it became it was not just my favorite moment, but just everybody in that room was like that line. And then we started quoting it every time we ordered lunch. It was like, I'm getting this, I'm getting the yuzu salmon.
What you like?
Sweet greens, what about you?
Blake lively communicated with herself in court through her shell company, Vanzan Inc. Her personal legal team was in conversation with the attorneys representing Vanzan, meaning Blake effectively orchestrated discussions with herself in legal filings, while acting as though these were two distinct parties. This shell company, Vanzan Inc., filed a lawsuit in September 2024 in the Supreme Court of New York County. Oddly, it named no defendants. The case made little legal sense, but managed to subpoena Stephanie Jones and her firm, Jones Works, demanding access to all data from Jennifer Abel's phone. Shockingly, neither Jen Abel nor any involved party was formally notified. There were no publicly available court documents or relevant justification for the lawsuit. Jen Abel had no connections to Vanzan Inc. Now, Abel is fighting to retrieve a copy of the subpoena and all the documents shared with Jones Works, including their communications and background on the company itself. The reason Blake Lively put a protective order in place is becoming increasingly clear. It was meant to block discovery and restrict transparency. It appears to be a legal chess match where Blake and her legal team are bending the system. The protective order includes a confidentiality clause, forcing any party who receives designated material to sign an NDA. That NDA restricts the user from disclosing or sharing any information beyond the scope of the case. Blake's team taunted Abel, stating that the discovery had already been provided, in a case that Abel was not a part of, and noted that even if she had the materials, they were confidential and unusable. When Abel filed a motion to compel, she explained to the court that Vanzan Inc. was merely Blake Lively's shell company, and that the subpoena was used as a backdoor to collect discovery materials. Blake's lawyers even admitted the strategy was used to obtain this specific information. Strangely, Vanzan then hired new outside counsel, different from the firm representing Blake, suggesting a potential cover-up or shift in strategy. The tactic is disturbing. Blake is weaponizing corporate veils and legal loopholes to evade accountability. It's manipulative, and the fact that a judge might entertain this tactic is alarming. If Judge Lyman supports this, it'll show that justice is not the goal of this court. The entire process reeks of deception. Blake Lively's arguments flip between offering evidence and simultaneously withholding it via confidentiality clauses. This creates a legal paradox that keeps Abel in a stalemate. Blake's side even accused Abel and Wayfair of using the court to further a negative PR campaign against Blake, claiming that this motion was simply a media tactic. They argued that the documents Abel sought were either already in her possession or irrelevant to the case. They maintained that her complaints about the Vanzan lawsuit were baseless and unsupported. Additionally, they suggested that Abel was misleading the court by pretending she didn't already have the documents produced under the subpoena. They claimed Abel had ignored communication for weeks and abandoned the meet and confer process before filing her motion. Vanzan argued that the motion should be denied because Abel already had the documents, or they were irrelevant. Still, they offered to produce documents related to items 10 and 11, as well as parts of Requests 1 and 4. Regarding Request 9, which involved communications between Vanzan, Jones Works, and their attorneys, Vanzan argued Abel should seek those directly from Jones. Ironically, Abel had already told the court that Jones refused to provide these. The hypocrisy is glaring. If Vanzan had no involvement in the lawsuit involving Abel, how did they obtain her phone data? It suggests a coordinated strategy, possibly designed to shift blame onto Wayfair and make Abel the villain. Blake is distancing herself from responsibility by using Stephanie Jones as a buffer. If Jones handed over Abel's phone data without consent, Blake gets deniability. Yet the events that triggered this, Abel's firing and the phone retrieval, occurred before the Vanzan lawsuit even began. So how did Vanzan know where to look unless it was all coordinated? Blake's legal team claims Vanzan is not a party in the main litigation involving her, Wayfair, or Abel. That's misleading. Her own legal filings reference the subpoena obtained via Vanzan. They use the shell company to do the dirty work, then deny its connection. They further claim Abel should get any remaining documents directly from Jones, even though Jones refused to cooperate. Blake's team then accuses Abel of using the court to create PR stories, rather than for legitimate discovery. Vanzan maintains that if Abel really needed confirmation of the documents, they were willing to reproduce them. They even offered to share publicly available incorporation records and board member consents to satisfy certain requests. However, Request 9, communication between Vanzan and Jones works, is supposedly unavailable because Jones holds those materials. Vanzan attached email exchanges showing Abel was unsure what she could disclose due to the protective order. They demanded Abel confirm if she had the subpoena documents, even though such disclosure could violate the protective order and risk contempt charges. In their objections, Vanzan painted the lawsuit as fully justified and accused Abel of deflecting from her own misconduct. They argued that most of Abel's requested documents had no relevance, and she already had access to her own communications, or could obtain them via standard discovery processes. But that argument is flawed. Abel's phone was taken, and her access to its contents is gone. She's not asking for redundant records. She's asking for the return of her stolen data. Blake's team portrayed Abel's actions as a smear campaign designed to retaliate for Blake raising harassment concerns. They argued that Abel had orchestrated media coverage and false narratives, but the actual behind-the-scenes communications told a different story. Abel had encouraged colleagues, supported them emotionally, and had not pushed false stories. Even if she called Blake a derogatory name, the substance of the harassment allegations must still be addressed. This isn't about name-calling. It's about accountability for data theft, legal manipulation, and retaliation. Melissa Nathan and Stephanie Jones, two key PR figures, appear to have played central roles in orchestrating counterattacks against Abel and Wayfair. Jones allegedly shared Abel's phone data with Leslie Sloan, who warned of an incoming lawsuit. That alone is a massive breach of confidentiality. Now Jones is attempting to subpoena Meta and Pinterest to uncover the identities behind social media accounts critical of her. She's alleging that employees linked to Nathan created defamatory pages. Yet the claims, like Jones being known to leak info, are arguably opinion or based on true events, making them difficult to legally challenge. Jones argues that posts falsely accused her of serving bogus legal threats and leaking client information. But others, including the narrator, have also received baseless legal threats from Jones. If these accounts are expressing opinion or sharing true experiences, they may be protected speech. Jones claims Abel and Nathan secretly conspired to destroy her PR firm, steal clients, and create smear campaigns. She insists they worked with Business Insider to publish hit pieces. However, many of those sources were independent former clients or employees who confirmed the negative culture. The Business Insider piece, titled "Who's Afraid of Stephanie Jones?" alleged misconduct and publicized the Stephanie Jones Leaks website. The article aligned with what many had experienced, even if Jones considered it defamatory. Abel was accused of orchestrating that coverage, celebrating its release, and planning her departure from Jones' works. She's also accused of working with Nathan to shift the Wayfair account away from Jones. But none of this proves illegal behavior. It reflects clients and employees choosing to move on from a toxic workplace. Jones also links actor Justin Baldoni into this alleged conspiracy, claiming he feared exposure of his toxic behavior and tried to protect his image. But again, many of the claims are based on employee experience and testimony, not tabloid gossip. Stephanie Jones' declaration portrays herself as a victim of a years-long conspiracy, despite allegedly engaging in aggressive PR tactics against others. Her outrage at being treated this way is ironic, considering her alleged past actions. If true, her actions, spreading sensitive client information, retaliating against former colleagues, Misusing legal tools show a toxic pattern. In the PR industry, such behavior isn't just unprofessional, it's dangerous. Whether or not some online posts were defamatory remains legally debatable, but much of the content reflects opinion or shared personal experience, both of which fall under free speech. At the end of the day, if publicists and their clients are manipulating the legal system and media narratives to bury accountability, we all lose. And if the courts enable it, that's worse. Let me know what you think in the comments. Don't forget to like, subscribe, and hit the bell for future updates. Thanks for watching.